Okay, why don't we go ahead and get started? We have a smaller group today, which is good at times, certainly. If anybody during the course of the today wants to reach out and ask any questions, feel free to do so. Welcome to the second Wednesday series. And given the fact that it's the holidays are approaching, we thought it'd be appropriate to discuss family law issues and how those relate and can become problematic during the holidays. Maybe give a little bit of background on what people can do to prevent problems, to try to troubleshoot problems if they were to occur. And with us today are two of our family law attorneys, Jacqueline Dupler, better known as Jackie, and Gabrielle Lawrence, better known as Gabe. They both do family law almost exclusively. I think Jackie does it exclusively, and Gabe does a great part of her practice. So and they're very well versed in it. They've represented individuals in family law matters for many years, and certainly are experts in the area. And so I'm happy to have them both here with me today, and hopefully everybody will be more informed of what can happen during the holidays. And again, the holiday season is fun, can be overwhelming. There's a lot going on, a lot of stress, a lot of work stress, deadlines, that sort of thing, Christmas shopping, travel, work, family, everything going on at once. And then if you have a scenario where you have a parenting schedule following a divorce, or you're in the pendency of a divorce and you're trying to develop a parenting time schedule, that adds another element of stress to the whole scenario. So let me just start in terms of things that we can do to address these issues. The first question I have or concern is just basic. It's just like, what is parenting time?
Dave, do you want to go first? Do you want me to go first? Go ahead. Okay, so I mean, put simply, parenting time is time that you have with your child or children. If the court is involved, then there would be a parenting time schedule ordered by the court. And that can take a lot of different forms. So just a very general answer to start.
There used to be, when I was younger, when I was a young attorney, there used to be something called visitation. Is parenting time the same as visitation, or is there any difference in those?
We don't really use the term visitation anymore. Parenting time, like Jackie said, it's just time that you spend with your child. It is different than custody. There are two different, I don't want to get in the weeds too much here, but there are two different kinds of custody. There's physical and legal custody, but parenting time is just the physical time that you are in your child's presence and they are in your care. And that's going to look different for every family and every scenario.
Okay, I guess parenting time sounds better than visitation. Visitation sounds like if you're going to come and you're going to go and you're not going to have any time.
It sounds a little bit like you're in custody, right?
Exactly. How is parenting time determined? I mean, who makes that decision?
So that'll be something that is detailed in your divorce documents and in your friend of the court documents. As I mentioned, it's going to be different for every family. Some families keep it simple. They have week on, week off. Some families have, one of the parents has maybe every other weekend, maybe a 2-2-3 schedule. They're all different. There's a myriad of ways that parenting time can be split up. So it's important that people are familiar with their judgment of divorce, their friend of the court documents, because it's going to be really important to look at those documents and to understand exactly what your parenting time schedule is, in particular, what your parenting time holiday schedule is, because that can look different from your normal week on, week off, for example. And that holiday parenting time is going to take precedence over what your normal underlying general schedule is.
Is there a standard parenting time for holidays? Does the court come up with a standard parenting time that they would like you to use by county or by friend of the court, or how does that work in terms of parenting times, like Christmas Eve, Christmas Day, that sort of thing?
So that is, it depends. I mean, unfortunately or fortunately, in the world of family law, everything is and it depends because there's a lot of detail and a lot of variation. Most counties do have a schedule that they use that is kind of their cookie cutter or presumed schedule that they use to divide holidays. Admittedly, they are based off of a Christian calendar. So most of the counties don't have a schedule that automatically addresses how to split Hanukkah, for example,
or other religious holidays. So there is kind of a cookie cutter schedule, but the court does allow, and most counties even encourage families to really think about what actually makes sense for their family, whether we're talking about religion or other traditions. And so just a really minor, tangent maybe, is that, for instance, one case specifically, I had the husband was a military veteran and Memorial Day was really important to him. And the other party was had coincidentally a family reunion with the extended family on Labor Day weekend. So instead of saying each of them gets every other Memorial Day weekend and every other Labor Day weekend, we were able to come to an agreement where one party gets every Labor Day weekend and one gets every Memorial Day weekend. So we can kind of honor what makes sense for this family, not use a cookie cutter approach. So I think it's important that if somebody on this presentation or in this meeting is considering, filing at any point, that they really consider what makes sense for their family and their traditions. I think Gabe might have more to say as well.
Another just quick note on that. I know that something Jackie and I always ask our clients is, are there any particular events that are important to you that might not be addressed in that cookie cutter holiday parenting time schedule? For example, I had a client whose family always celebrated Christmas on December 23rd. It was extremely important to her that she have her children that night. The husband knew that and he was okay with that, so we baked that into their judgment of divorce. I had another client where one of the parties was a member of a Native American tribe, and it's important to one of the parties that the children be able to attend and participate in powwows. So we've built that into the schedule. Every family has their own things. Everybody knows kind of we celebrate Thanksgiving early, or Halloween is super important to us, or whatever it is. So just if you're thinking about filing for divorce in the future, just take note of those things. What days do you want to be sure you have the kids, essentially?
And that changes over time, correct?
Of course, it always can. And these documents generally don't last from when the kids are little, when the divorce is finalized until the kids are 18. Generally, these documents ebb and flow. They change as the kids get older, their needs change, the schedules change. There are always different ways we can address that.
Okay, and if the other side won't agree to it, a change, if something changes in circumstances, job changes, that sort of thing, and I'm just talking holiday time, and one of the spouses needs to fluctuate their time, and the other spouse won't agree to it, can they go to court and seek redress there?
Yeah, we can always file a motion, always go to court. That's, of course, kind of the nuclear option, the expensive option. It's always better for the kids, frankly, for the parents to work through these issues by themselves. But we all recognize that sometimes that's just not possible. And that's why Jackie and I have jobs and are here to help people navigate these issues when you need kind of a third party to step in.
And if I can piggyback, sorry.
Oh, no, please.
But if I can piggyback on that, I think that is maybe a good time for us to reference that it's important that you look at your order, that you know your order, that you review it in detail, you put those dates into your calendar so that when you're looking to take time off of work or schedule a vacation, you know when you actually have the children. I have seen unfortunate situations where somebody doesn't look at the order and they schedule and maybe they buy tickets for Disney and then the other person won't say yes. And then you're out a bunch of money because you don't have the kids. So making sure people look at this ahead of time, especially if there's something really big. Say your family's doing a big extended cruise or something like extended family cruise during the holidays, you want to make sure you know what days you have. And if you don't have the days you want, that you have time to have that conversation with the other party. And if that isn't fruitful, that you might have time still to go to court. You want to make sure you don't wait until Christmas Eve to let everybody know there's a problem.
And how far in advance should you, if you can't seek a resolution of your spouse or former spouse won't agree to the change, how far in advance would you need to get into court in order for the court to make that decision in time?
It's, as far as possible. Courts, a lot of courts in our area are still dealing with COVID backlogs. It still can take several weeks or a few months to get a hearing date. If it's an emergency situation, obviously we would address that on a case-by-case basis. But I know I have 2 young kids and their spring break is in March. So we started thinking about spring break dates last spring. My recommendation to people is just think about these things absolutely as early as possible to make sure that we've eliminated conflict. And if there is conflict, that we've got plenty of time to go before the judge or the referee, whatever we need to do.
Okay, we have a question that came up, which is relevant to what we're talking about right now. And is how much help is the court when the other spouse is unwilling to compromise or agree to accommodate a holiday? Will the court really get involved in this type of dispute? Will they just default to the temporary order?
That's a really good question. And unfortunately, I'll say that I think it's going to depend on what holiday, how far in advance we're talking, what accommodation you're seeking, and admittedly, who your judge is and how they are willing to handle it. I think, for instance, if you're asking for something really minor, like our flight gets in at this time, can I be 1 hour late to the exchange? I think that that's more than likely a good possibility that it could be granted. But if you're saying, I want to take the other person's entire Christmas break just because, I think that's very unlikely to get granted. I also think that if you're seeking some sort of accommodation, that if you're being reasonable and respectful in your communication to the other party, and if you're asking or offering that you give them something in return, then I think you have a better chance of being successful than if you come in there, barking or demanding that they just give this to you because you want it. You need to make sure you show a level of respect to the other party as well.
Okay. And just following up on that question, it wasn't temporary order, it was blocked in my chat, but it says, will the court just default to the template schedule, or will it side with one or another spouse? Or will the court try to seek a compromise?
I think it depends, to be honest, again, on what's being requested. I think if it's an all or nothing where you want to just take away somebody's entire Christmas break, I think the answer will likely be no. And I don't think the court would encourage compromising. But if it's a small accommodation, especially flights around holidays can be really expensive. So if you're looking at a flight and it's dramatically more money, if you come back 2 hours later, the court might be willing to say, well, why don't we just make that accommodation and the other person gets 2 extra hours tagged on at the end of their time. So I think it depends on what's being requested.
And sometimes when the 2 parents are unable to come to a compromise, before we get to the judge, attorneys might step into this role as well. And very frequently, attorneys are able to come to a compromise between the 2 of them, and kind of fix that problem before we have to file a motion, before we get to the judge. I know Jackie and I both are super friendly and have good relationships with so many of the family law attorneys in our area and throughout the rest of the state of Michigan, which is really important when you're dealing with a family law attorney. You want an attorney who can work well with the other side, who can help your client and the other party navigate these issues. Of course, you have to pay for legal representation, but if your attorney can help navigate that issue, it's generally going to be a lot quicker and easier than waiting for the judge to weigh in.
Okay. Well, let's move on a little bit from parenting time, because we don't have a ton of time. What is co-parenting?
So can I go first? Okay, so co-parenting is really, it encompasses a lot, but it's communicating and working together with the other parent to do what's best for your child. It's not always an easy process, of course, depending on how your relationship is with this person, if you 2 get along or not. So we understand that it's not always easy, but you need to make sure that you're guided by doing what's best for your child, and really remember and maybe repeat to yourself in your mind that all you're trying to do is love your child more than you hate the other person. And, if that means you compromise on something or you give them extra time because they have a special event they want to take the child to, then then you do what's best for your kid. So fun example, I guess, is say that the Eras tour is over now, but say the other parent was able to get Taylor Swift tickets and it happens to be on your parenting time and your child is a huge Swiftie and wants to go, you should probably let them go. You shouldn't say, well, no, that I don't have the ticket, so no, you can't go. Right? I mean, that's not really fair to your child. So trying to say, you know what, yes, you can have that Friday night. Can I have the following Friday that's normally yours? And work it out. And you're just doing what's best for your child. You just have to put your pride aside, your other emotions about the other party, and work things out.
And when we get to co-parenting during the holidays, there are so many little details that you have to think about. We know the holiday time is super busy, especially when you have kids who have school events and sports games and all these different, breakfast with Santa, whatever's going on. And there are things that generally both parents want to be involved in. They want to both go to the band concert or the choir concert or whatever the event is, but it's going to occur during someone's parenting time. We always encourage people, be willing to work with each other, be willing to sit in that auditorium at the same time and not make it contentious. You don't have to sit together. You don't have to sit next to each other. Sit on opposite ends of the room if that's what you need to do, but don't put your child in the middle of it. Create that environment where the kid knows my parents are both here. They're both here to support me. They love me. And we're going to be okay. And this isn't going to be a miserable evening. So there are all these different issues that come into play, but we always just encourage people, think about the kids, think about the best interest of the kids, because that is absolutely what the court is going to consider.
What happens if during the holidays, one parent prevents the other parent from exercising or utilizing their parenting time? Like, what if somebody says, I'm not going to drop my son or both kids off at your house, even though I'm required to on Christmas Eve? Or just doesn't show up?
Difficult because if it's, 6 p.m. on December 24th, there are frankly very limited options that we have. The police aren't going to get involved. The court's not going to have an emergency hearing on Christmas Eve night. Generally, the path of least resistance is call your attorney on December 26th and explain the situation and address it right then. Unfortunately, there's no immediate solution most of the time, but there might be a trade-off. If one parent refused to give the kids to dad for his Christmas Eve pursuant to the order, then maybe he gets Christmas Eve next year, or maybe we make it up to him somehow else, somehow differently. But there's not a great way to address that right when it's happening.
And following the holiday time period, could the person who's been deprived of the parenting time go to court, and what would they ask the judge to do? Would they ask the judge to sanction the other party, give them the makeup time? Would the judge sanction the other party, and would the judge give them makeup time?
I would say that makeup time is pretty much a given. I can't see a world in which the judge would say, no, that's unfortunate, and you're kind of just stuck. Typically, when judges give makeup parenting time, they want it to be of the same nature. And so I have not seen a holiday situation where the court says, well, you just get a random Tuesday, right? I mean, they're generally going to say, well, you didn't get your Christmas Eve, Christmas morning, so next year you take the other person's Christmas Eve, Christmas morning, and there's a new order issued that addresses for that one-off specific situation. In addition, there are sometimes where situations where if there have been repeated violations of the order, the court is more inclined to order fines be paid or other penalties. But it's also important that you file something so that the court has a record of such a big problem. So that if 2 or 3 years go by and different holidays, this same game is played, that you're kind of creating a paper trail for the court's record if you need to file a bigger motion in the future.
Will a court, if there's repeated abuses of parenting time or failure to provide it, will a court modify the parenting time schedule so that the parent that was at fault is deprived of parenting time almost entirely, or curtail it significantly, or what will the court do?
There are a lot of different things the court could do to address that. So they could order makeup parenting time. They could order a complete overhaul of the parenting time schedule, of the exchanges. They could put that person who's keeping the kids, who's depriving the other party of their parenting time, they could put that person under a lot more scrutiny, under a lot more control of the court. Courts don't like this. Courts don't like to play around with one person using the kids as a weapon against the other party, because that's really what we're doing here, right? We're putting the kids directly in the middle and depriving the other party. All of the laws in the state of Michigan are geared towards fostering and nurturing a relationship between the child and their parent. The children have a right to have a strong relationship with the parent. Everything the court's doing is geared towards protecting and nurturing that relationship. So when one parent is taking advantage of that and just kind of thumbing their nose at the order of the court, that's going to be a major problem. And there are a lot of different ways the court can essentially punish that person who's not following the terms of the order.
I could probably come up with 100 scenarios, but what if it's a situation where a parent has their parenting time and they take the kids and they bring them to their home, and then they have, say, their new spouse or their parents spend all the time with the kid, and they go off on a fishing trip or go off to a Lions game or something like that? What happens then? Will the court look at that as negatively on that parent? I mean, will they restrict them from future parenting time if the parent has the parenting time, takes the children, but doesn't spend any time with them?
The court can. I think it's another one of those where it depends how serious it is and how frequent it is. But the courts also recognize that, grandparents, cousins, other people have a strong relationship with a child. So extended family time is not a bad thing. But it is a bit of a balancing situation and really depends on what's going on. So unfortunately, there's not like a clear cut that I'm aware of.
Okay. We're running a little bit out of time, and I guess in summary, what it sounds like to me, and certainly you can elaborate on that as much as you want. It sounds like to me that you should have a specific parenting time schedule that covers the holidays. Make sure that everybody's on board with it. And if there's any concerns or any changes that you want to make to it, you need to get to the court as soon as possible in order to do that if the other side won't agree. Correct?
Yes.
Now let me carry it a little further. So if you reach an agreement, say in October, that you're going to make some changes to your holiday parenting time, what do you do? Do you memorialize that in a letter? Do you put it into an order? Do you have the judge sign that order? Or do you just say, okay, we've agreed to this and we have a text exchange on it, this is what we're going to do, and that's good enough?
So if you come to an agreement, we would memorialize that in a stipulated order that would be entered with the court, because we want the court to be on notice that there has been an agreement reached, and we want it to be an order of the court, because we don't want one party to go back and say, yeah, sure, I agreed to that in October, but now it's December and I want those kids on Christmas Eve. So we always want everything to be in the court file. We want the court to know exactly what the situation is that they would be enforcing. And your attorney can help you with that.
Can somebody do that without hiring an attorney? Can somebody go to take their court documents and then go to the friend of the court or go to the court itself and make those changes on their own order and have it signed by the judge?
Yes, there are a lot of things that non-attorneys can do. Paul, you mentioned that I have other areas of practice. The other area of practice is estate planning. So I deal with a lot of deeds. There are a lot of deeds that people can prepare without the help of an attorney, but it's really hard. And those documents tend to get rejected a lot. And maybe the stipulated order that you're trying to enter isn't as clear as it would be if an attorney were preparing that for you. So in a nutshell, yes, a lot of these things people can do on their own. But in my opinion, it's always better to have an attorney involved, at least on one side, just to make sure that that document is not going to be rejected by the court and that it's as clear as possible, so you know exactly what you're agreeing to.
Well, I think we're just about out of time. I don't see any new questions in the chat. If anybody wants to post one, certainly go ahead. If somebody wants to come on and ask a question here, you can do that as well. And if anybody wants to follow up with Jackie or Gabe, feel free. I think Jake had sent around their email addresses and their contact information, so feel free to contact them to discuss it. But I think that's all we have for today, and I hope everybody has a good holiday, and everyone has a non-stressful parenting time situation.